Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about Indigenous people protesting. Cases that should have gone to the Supreme Court of Canada, but didn't. In the course of protests in British Columbia related to massive development projects, an individual named Angela Davidson, the former deputy leader of the Green Party, was arrested on 12 separate occasions for breaching court orders banning protesters from the location. Angela is an Indigenous person, and she argued at her sentencing hearing, after pleading guilty to the offenses, that the perspective of her as an Indigenous person and her obligation to the land and as a land defender within her indigeneity should be something that should be taken into account in sentencing. That Indigenous perspectives about the offense that a person is charged with, particularly when an Indigenous person is committing the offense as an assertion of their authority over the land, should be taken into account and should be considered a mitigating factor on sentence. The court disagreed. Leave to appeal was requested from the Supreme Court of Canada, which was denied. And this case is a very important case. This deals directly with issues of truth and reconciliation that should be dealt with by the courts. We have right now in British Columbia the courts asking for input on reconciliation projects that the court can engage in. We have all of the recommendations from the Truth and Reconciliation Commission related to the justice system that include considering things like Indigenous perspectives and incorporating them into the way in which justice is done. And yet, the BC Court of Appeal had an opportunity to do this, and the Supreme Court of Canada had an opportunity to chime in, and unfortunately, they didn't take the opportunity to make some law that pertains to how reconciliation actually works when it comes to Indigenous people who are acting in a way that is contrary to law on paper, but consistent with their traditional laws and their traditional obligations. It would be nice to see the Supreme Court of Canada wade into these waters, because it is likely, as we continue to see resources exploited across the country for more development, that this type of protest and these types of incidents are only going to be on the increase. And so the Supreme Court of Canada giving some guidance about the way in which the Indigenous perspective can inform the sentencing process, separate and apart from the Gladue process, should be something that the Supreme Court of Canada should give guidance to trial judges across the country on. Hopefully, this doesn't take another number of individuals having to be arrested for contempt, charged, and sentences before the Supreme Court of Canada takes the opportunity to hear this again. And hopefully, when they do have the chance to deal with this issue, they recognize that this is not just an important issue to the development of the law in Canada, it's also an important issue to Indigenous people and to the obligations the court has to reconciliation. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Reasonable Creative for putting together these videos. Please like, subscribe, and share with your friends.